Welcome to today's discussion on commenting on the comments and expert take on the direction of FTC privacy rulemaking. This discussion is hosted by the International Center for Law and Economics. My name is Gus Horowitz. I'm a professor at the University of Nebraska and the director of Law and Economics programming at the International Center for Law and Economics, and I'll be moderating today's discussion. In August of this year, the Federal Trade Commission released an advance notice of proposed rulemaking, or ANPR, relating to, quote, commercial surveillance and data security. An ANPR is a legal requirement when the FTC wants to use its consumer protection authority to issue rules, and it's intended to, quote, invite the response of interested parties with respect to such proposed rulemaking, including any suggestions or alternative methods for achieving the objectives of the rulemaking, and also to obtain suggestions regarding the content of the area of inquiry before the publication of a general notice of proposed rulemaking. In other words, an ANPR is intended to inform the world about the FTC's plans to make rules and begins a fact-gathering process to help the Commission in drafting the rules that it will ultimately propose. This process deviates from the ordinary process that federal agencies are required to use when drafting new rules. Congress added Section 18B of the FTC Act in 1975 and further changed it in 1980 to impose more onerous procedures on the FTC's use of its rulemaking authority, largely out of concern over the Commission's aggressive use of this authority in the 1970s. The fact-gathering process includes holding hearings and soliciting public comments. Initially, in this ANPR, these comments were due tomorrow, October 21st, though the Commission recently extended that deadline until next month. I'll briefly note that this morning, the International Center for Law and Economics, the host of today's discussion, published an executive summary of its comments, which are now available on laweconcenter.org, the executive summary, that is. Our topic today is the likely contents of these comments and, more generally, the likely direction of the FTC's eventual rulemaking in this matter. For this discussion, I'm joined by three stalwarts in the field, frequent commentators and participants in Federal Trade Commission activities. Our first panelist is Professor Jane Bambauer, who is a professor of law at the University of Arizona. Jane has published extensively on privacy and consumer protection issues and engages frequently with the Federal Trade Commission. Our second panelist is James Cooper, professor of law at the Antonin Scalia Law School. James has previously served in many capacities at the Federal Trade Commission, including as the Deputy and Acting Director of the FTC's Office of Policy Planning and as the Deputy Director in the Bureau of Competition Protection. I have it on good authority that James also once worked at an Olive Garden and arguably was the boss of our third panelist, Dan Gilman, who is a senior scholar at the International Center for Law and Economics and a former FTC advisor. In terms of our own process for this discussion, I have several questions lined up to start our discussion, and we'll begin with those. After about 30 minutes of discussion, I will invite questions from the audience, which I will then incorporate into the discussion. If you do have a question, please submit it using the Q&A feature in Zoom at any time, and we ask that you include your name and affiliation with your question. Okay, with that as an introduction, the name of the ANPR, or the subject of it, is commercial surveillance and data security. And the FTC has a long history of regulating or engaging in actions relating to privacy. Nominally, this ANPR comes from or stems out of that activity, but it's being called commercial surveillance. So we're going to start with Jane. Jane, can you tell us what is meant by, quote, commercial surveillance?
Well, the FTC defines it as a collection, aggregation, basically use, transfer of personal data, whether that data is collected through some sort of form where the consumer knows that they're filling it out and providing data, or whether it's kind of passively collected, like browser data or cookies and whatnot. But I think the kind of subtext of what you're asking, Gus, is why they're using this sort of term rather than either privacy or just data collection. And I think that, I could explain it in a couple ways. One is that I think surveillance is a bit of a loaded term, and the ANPR itself is also a bit loaded, I'd say stacked toward the assumption that these practices are bad and bad for consumers and harmful and sort of sneaky. And so it doesn't hurt to sort of convert the language to the sort of word that people use to suggest sort of totalitarianism and lack of control and whatnot. The other reason is that Shoshana Zuboff's book, Surveillance Capitalism, was a pretty big hit, even in the general public, and wound up being, the subject of several New York Times op-eds and commentaries, and so I think there's sort of a transition in the field of privacy advocacy toward using this term as well.
James, I'm going to ask you the same question. Your thoughts on what is meant by the term commercial surveillance, perhaps why it's used, but also more generally, how this term relates to the FTC's work in privacy.
Yeah, thanks, Gus. Thanks for inviting me. It's great to be back on with my former subordinate Dan, and the reason I have a green background is, of course, a shout out to the Olive Garden. But the more seriously, and I definitely agree with Jane. Why commercial surveillance? I think that's a shout out to Shoshana Zuboff. In some ways, it seems as if to me, when you see an ANPRM, when you see this advance notice of this proposed rulemaking on commercial surveillance, it does suggest that there are, some of this are already, some of the decisions have already been made, because commercial surveillance is a very loaded term. It's right up there with surveillance capitalism, which is, of course, Shoshana Zuboff's phrase that she coined. So what does it mean? I mean, if you dig into the document, of course, it seems, there are two broad themes. There's a lot in there. There are 93 questions, give or take. So they cover a lot of ground, but I break it into two. One is, broadly, it's addressed at the online advertising ecosystem, for lack of a better word, in the sense of online tracking, and then using information gained from tracking to target ads or target offers. In that, there's kind of a privacy part of this proposed rule, which is about the collection and use of this data in and of itself. Does that violate privacy norms? Is that something we should be concerned about and the FTC should act on? And the other side of it is the algorithm side. I think in some ways there's a lot in there about fairness and the use of these data, whether it's serving only, you don't see the right ad, certain people only see certain ads, or certain people only get certain offers, or the extent to which the data collected online can bleed into offline discriminatory practices, that sort of thing. So I think, that's broadly what they're getting at, these kind of two, the privacy and maybe broadly discriminatory harms that come out of collection and use. Now, to drill down a little more on your question, what does this have to do? How is this related to the FTC's program? The FTC has been in the privacy arena for over 2 decades now. They're in the late 90s under Petofsky. They realized, there isn't a national privacy law. But there's this thing called the internet. It was at the time really more e-commerce, but we needed to do something. So, there were some pretty high profile reports in the late 90s. One, originally asking for congressional rulemaking, then later not, saying let's do this under more of a self-regulatory sort of and use deception and unfairness. So since then, certainly since the Muris era in 2001, they began using unfairness and deception to police the privacy issues, primarily deception. In the deception, well, it started with, hey, did you promise something in your privacy policy and you explicitly broke it? I'm not going to collect data and I'm not going to give it to a third party, but actually it turns out you're collecting data and giving it to a third party. Those were the low-hanging fruit. What is been what's been considered a representation has grown greatly since then as to what, a representation that a consumer can take away a privacy, from which a consumer can take away a privacy claim, has grown. But still, by the same token, they've still pretty much relied on deception. There have been unfairness theories, but most of the unfairness theories, and not to get in the weeds here, but I guess if you're ever going to get into the weeds about the FTC, this is the place to do it, right? That with the deception, the remedy you get for a deception, and by the way, all of these have been brought in-house, admin law, and all settled, or under the administrative law judge, and all have settled all these privacy claims. The remedy you get when you plead deception is an informational remedy, that you need to stop lying. It isn't to bring your privacy practices up to what you promised. It's to stop lying about your privacy practices. So if you can still share data with third parties, you just can't tell consumers you're not. In fact, you don't even have to say anything. I mean, and that's another part of this quasi case law that's out there. They're all settlements, is that there's not there's no sort of disclosure. Not disclosing what you're doing is not a deceptive omission, though query there's one case that may get there. So where I was going with this, the background, if they've used unfairness, which is where you can go after the actual conduct, and very, very sparingly, and under the only for very egregious violations of privacy, turning on webcams to see people's babies or to see people in their home when they don't know about it. Like that's kind of the quintessential use of unfairness. What for the rulemaking, a practice has to satisfy prevalence and specificity, and we may talk about specificity later, but prevalence, you get that. It has to be a prevalent practice. You can get that from the cases. Now, like I said, the FTC's done a lot of cases. There's no doubt they can do that, but this is a departure from where this is moving beyond where their current case law has been as far as prevalence, addressing practices. There's never been a case absent deception where they've said this sort of surveillance is an unfair practice, and that would be the only hook you could use. So it seems that they're kind of moving past where they are, and we can perhaps get into this in detail a little later.
Thanks, James, and I expect that we will touch on that. Certainly an issue that we would expect to be featured pretty prominently in some of the comments coming to the FTC. Dan, turning to you for a first question and some thoughts. As James notes, we've got Deception Authority and the Commission's Unfairness Authority, and it's proceeding or suggests it will proceed using its Unfairness Authority. And a key issue here is that Section 5N of the FTC Act requires what amounts to a cost-benefit analysis for unfairness actions. How do you see cost-benefit analysis being represented or considered in the ANPR?
It's a good question. There's some. It's a little slender in some regards, or a little tilted. So we can think about two things. One is the statute, the Magnuson-Moss amendments to the FTC Act say they can't find conduct unfair unless it causes substantial harm to consumers, not reasonably avoidable by the consumers themselves, and not outweighed by countervailing benefits to consumers or competition. So there's a statutory requirement that they do something very much like a cost-benefit analysis. When we think about cost-benefit analysis, we can think about it sort of on two levels. One are the costs and benefits associated with the conduct at issue, and the other question is, what are the costs and benefits associated with or likely to be associated with regulations adopted to deal with the conduct? And starting with the conduct, I think just following up on James and Jane, There's an interesting definition of commercial surveillance. On the one hand, it's really, really sweeping. On the other hand, it's pretty vague. So some key terms are not defined. There's all sorts of things: collection, storage, use, analysis, dissemination, etc., of consumer data, but they don't define consumer data. So are we talking about what's called PII, personally identifiable information, on some construction of PII? Are we talking about sensitive personal information, what's called SPI, on some particular construction of that? I mean, they don't say. They've been running cases for 20 plus years. They've had workshops, reports, all sorts of hearings, etc., and they just don't say. So what are the costs and benefits of the conduct at issue? Well, we might want to know a little bit more about the conduct at issue, because, as James pointed out, it's not a term that's come up in FTC cases brought internally in the administrative process. It's not a term that's been defined in the federal case law. It's not a term that's defined in the FTC Act or any other statute that they're talking about, or any regs. So it's a highly atmospheric term. They've got a definition, but we might wonder what it is. What does the ANPR do? Well, there's a lot of talk about harms, actual, demonstrable, potential. Some of them are really clear and concrete and familiar. Some of them are a little hazy. And these are questions. The first 23 of the 95 enumerated questions in the ANPR, these are questions about harms. There's really not much about benefits from the conduct. In fact, there's this odd line in the opening section of the ANPR where they say, certain kinds of use of personalized information could provide consumer benefits in theory. And, one wonders, I mean, are the consumer benefits from the whole of the digital economy benefits in theory? I mean, whatever the costs and benefits on net, right, there's a lot of stuff we use. And this is true whether we're talking about a search engine or a social media platform, or, I go to the physician and the physician has an electronic health record and there's a portal and I input information. Well, that's commercial use of personal data, if anything is. So is that surveillance? I mean, I typed the stuff in. They don't seem to be recognizing any benefits of this. It's all very sinister. They do have several questions about the possible costs and benefits of regulation. Not nearly so much as questions about harms, the fishing expedition for harms far and wide. There's an open question whether they're really going to get the right kinds of information to do the requisite cost benefit analysis. I mean, to some extent, there's also a puzzle here. There's been all this enforcement action. There's been research by FTC staff, both in the Bureau of Consumer Protection and in the Policy Office, but also FTC is a very sophisticated Bureau of Economics, which has or had at one time close to 100 PhD economists. I think it's the number shrunk a bit, and there's no director currently, but lots of research tools, lots of enforcement background. There was, in fact, a workshop at the FTC on what they called informational injuries. There are no conclusions. There's no theory of what the FTC considers an informational injury. So I'll leave it at that. I think they raise the issue. They don't really tee it up as well as they could.
So I thank you, Jane, James, and Dan for those initial discussions. I want to loop back to Jane, both to give you a chance to respond to anything that James and Dan have said, and also to queue up discussion of our next topic, which is we've already kind of started to get to this. What are some of the concerns that seem to be motivating the FTC? And in particular, it seems noteworthy reading the FTC reading the ANPR, that the materials being cited by the FTC and discussed by the FTC, lots of news coverage, news reports. Oddly enough, Shoshana Zuboff is not directly mentioned, I think, in the ANPR, but materials inspired by her, lots of law review articles, but not much economic analysis. Not much reference to the past workshops and efforts by the FTC that Dan was just mentioning. So, Jane, I'll turn it to you, both to reflect on things that have been said so far, but also to reflect upon the sorts of materials that the Commission is looking to, but also are notably absent from the Commission's ANPR.
Great. Yeah, so there's this presumption that's been strong and sort of long-lasting in the legal academy that I think has spilled into the FTC culture, although Dan and James can correct me if I'm wrong, that economists come from a kind of ideological or ends-oriented kind of angle and don't really understand privacy. And I think that might be one reason that, despite the fact that there is actually quite a bit of research, empirical research, and also just sort of theory research as well, that helps flush out the benefits of the digital economy, it's not cited in this ANPR. I think this is a policy shop operation, and there's maybe even some deliberate avoidance of using some literature that's thought to be sort of tainted because it is too welcoming of kind of the digital economy. So I think this is reflected to some extent in what Dan noticed, that although there's some lip service paid to cost benefit analysis, especially asking about the costs and benefits of potential regulations, there's not really even an attempt to flush out the benefits, to ask, to ask a series of questions that can help structure an analysis of what consumers are getting today. This doesn't surprise me. I mean, I've heard some of the commissioners, like Commissioner Slaughter, for example, say that, for example, consumers and websites don't get a benefit from behavioral advertising. So they're sort of relying on one outlier of a study. There's this perception that the middlemen like Google and other ad networks get all of the advantage of the sort of extra money that's paid by advertisers for behavioral advertising, and none of it goes to content providers or websites that could then, use that extra money to fund their services. That's just it's pretty obviously wrong. I mean, just in terms of logic and economic theory, it has to be wrong, but then also every experiment and observational study, other than one that was based on only one publisher, has shown that actually there's a significant benefit to behavioral advertising in terms of the websites, the content that's produced. There's more content that's produced with, if not fewer, at least more targeted advertising, more relevant advertising because of behavioral advertising. And so consumers are getting something. So, using this as, I think, one of the core concerns that has driven the FTC to this point, the belief that behavioral advertising is very obnoxious to consumers, they can't get around it, and yet it adds no value. I think that's the philosophy that explains the ANPR. I'll just say one really quick thing about the other, we mentioned that they actually take a pretty sprawling approach, though, to thinking about, or to kind of highlighting problems that they've seen out in the wild and in the scholarship. And one of the other concerns is how people will be treated. So not just what kind of content or advertisements will be pitched to them, but also whether they might get different terms in a contract, whether they are, employment opportunities or just other opportunities, credit opportunities will change because of all of this extra new type of commercial data. that wasn't available in the past. And there, on one hand, I find that in itself a very interesting and difficult question that is not at all ripe. We're pretty early in understanding whether these algorithms actually have positive or negative distributional effects. So there's a lot of, I try to keep up with this literature, and there's a lot of evidence actually that when algorithms actually are used to select board directors or decide when child protective services should actually be used, the algorithms are less biased than the human alternatives, and so this is an area where I think it's the right time to be paying for government in some capacity to be paying attention. It is not at all the right time to assume confidently that we need to sort of suppress use of data. And in fact, many of the biases, the sort of best way to handle a intervention of some sort is actually to use more data, richer data, rather than less. And so there's some kind of internal tension, I think, with the philosophy that's running this that's running the show right now.
So James, I'm going to turn to you with basically the same question. It sounds like maybe Jane was casting aspersion on policy shop activities as distinct from economics activities. As a former acting director of the Office of Policy Planning, arguably the Commission's policy shop, I'll let you take up any further thoughts or response to that.
Yeah, no, this was so my I haven't been there in a long time in the policy shop. Dan's been there more recently than me. So and to be honest, I'm not really sure who would have, in my day and age, I think the Office of Policy Planning would have had a strong role in this, but because this is privacy, and often as I recall from my tenure there, and Dan and I both know, when you're dealing with privacy, you're not going to do it without the Bureau of Consumer Protection probably taking the lead. Now, I'm at there, or and more in particular, the Division of Privacy, DPIP, Division of Privacy and Identity Protection. I'm not really sure when I read this the extent to which DPIP, this is a DPIP document, or actually something that comes more from the chair's office. To be honest, I don't know. So I don't really know where the origin, who would have really run this. I know in my day that if you're doing privacy, BCP and DPIP really kind of run the show. But again, I'm not really sure where this came from. But one thing I do know where it came from is almost assuredly the Bureau of Economics had very little, if nothing, to do with this, which is a shame. As both Dan and Jane have already talked about, that the FTC, and granted, I'm biased as an economist who worked there and an economist who worked in the Bureau of Consumer Protection in particular. I mean, the FTC has got it's like a top university of IO and consumer protection economists. Some of the best consumer protection work comes out of there. So there are certainly people who are extraordinarily capable, and some of the best people in the country or the world to deal with some of these problems, in addition to just their overall expertise and brain power. They have a lot of experience. I mean, you think about the FTC is the one, and so the Bureau of Economics have touched all the major antitrust investigations against, the two current Facebook investigations, the Google search investigation that was search bias investigation that didn't go forward, but big investigation back then, and then all the privacy and consumer protection. So you have a lot of economists there who have been intimately familiar, going all the way back to Google double click, in some ways the original sin, right? I mean, that's some people think of it that way. The FTC there's really been no group of economists probably, except for maybe the Competition Markets Authority in the UK, that have been so intimately involved in this. And so, like I said, it's a pity that when you read this document, there's not a single cite to Catherine Tucker or to Alessandro Acquisti, two of the, leading economists who've done all this great empirical work, published in top peer-reviewed journals, that, in fact, Acquisti, and I'd add Liad Wagman to that. Liad Wagman, who's a recent departure from the FTC's Office of Policy Planning, who would be a normal person to have working on this, who's also done some great path-breaking work on economics of privacy. He, along with Alessandro Acquisti, and Taylor, did a big review article a couple years ago called "The Economics of Privacy," where if you don't want to dig into in the Journal of Economic Literature, it's like kind of the quintessential site. If you don't feel like actually digging into all the empirical and theoretical work that Jane and Dan have alluded to, all you have to do is pick that up. It's only like 50 pages. You could read that. There's not a single site to that, which for a sweeping proposal like this, and in fact, I mean my RA, went through and looked at the citations, because I was kind of shocked. 58% of the citations are to the original are to law review articles or media, and in fact, media is by far the biggest. It's about 30% of the original citations are to like the New York Times, the Atlantic, etc. This isn't how you make policy. I mean, I can say this going back from my days in the policy shop. If you tried to get a report past the chairman's office that cited newspaper, and it doesn't matter, I'm not talking about, which side of the aisle it's from. I don't mean like, oh, the New York Times or the Wall Street Journal would be no better. You either should be doing your own original research or citing the extant empirical research to support your propositions. I mean, the last thing I'll say, just kind of to wrap this up, is, as an economist, if you're going to remake this huge part of the US economy, do it based on good causal evidence. You shouldn't do it based on articles that come from whether the New York Times, the New York Post, the Wall Street Journal, I don't care. Investigative journalism is no substitute for good causal evidence, where you have random assignment and in particularly a well-defined counterfactual. Those are the hallmarks, and you've got this group of economists, these experts, and in the Bureau of Economics, who this is what they do for a living. They're well equipped to do it, and I hope going forward that as this becomes, if this becomes an actual rule and something they're considering, that the Bureau of Economics is really engaged, because to me, I read this and it's an embarrassment. I have to say, if I worked at the FTC, and I would be embarrassed of this product. It looks like a bad student law review article in many ways, the way it's all sort of put together with citations to other law review articles and to newspaper articles. That is not something a leading privacy agency proposing to remake the digital economy should do.
So it would be interesting, perhaps, James, to go a step further in that analysis and not just look at this type of sources being cited, but both the authors of those sources and the people cited in those articles. I wouldn't be surprised if there's some closed network of folks that you could work analysis. But I want to quickly note for folks in the audience, the question and answers are open. So if you do have questions, please submit them using the Q&A feature. We do have a couple that we will loop in. I do, however, the name of this event is Commenting on the Comments. And even though comments haven't been being submitted as much as we would have expected when the deadline for comments was tomorrow, I do want to ask the panelists what they expect to see highlighted in the comments that are submitted as part of the ANPR process. We've certainly heard some ideas, some issues already, what you expect to see in the comments, and also how you think that they are likely to affect the FTC's process moving forward. And Dan, I'll go ahead and start with you on this.
Sure. So, what's interesting, I expect there will be a lot of comments because there's a lot at stake here and a lot on the table. So I would expect comments from, privacy advocates, the privacy bar, the FTC and antitrust bar, other areas of policy. There's a lot at stake here for the tech industry. So I would expect comments from the tech industry and from their critics. There are wide swaths of academia interested in these things. I would expect comments from there too. One problem from my point of view, at least, with the ANPR is that although it refers to a lot of things, it's just so sweeping. There's no concrete rule proposed at all. There's no definition of consumer data. We don't really know what they're proposing. So comments could, in some sense, be all over the map. And they've asked for data. I'm sure people will send in data, but data could be about anything collected any way you like. If you don't have a focused request, it's possible to get lots and lots of stuff, but not focused stuff. And then there's the question, what you do with it, who does it, etc. And I think we're going to just have to see, but one might worry about a grab bag and then about picking and choosing. James brought up the wholesale lack of economic citations, certainly to the primary literature, but even to review literature. I don't want to dwell on my own perceptions, but this is just mine. There seems to have, I personally consider the Bureau of Economics to be sort of a jewel in the FTC's quiver. And a number of people, myself included, worry that they've been perhaps marginalized of late. The last director of the Bureau of Economics departed abruptly in February. We are late October and there is no director of the Bureau of Economics. Nobody's bothered to appoint one. Now the deputies are excellent people running the show. I don't know how important this is to the people behind the rule. One bit of inside baseball is you often look to the staff contact on some sort of publication as somebody with a central role. It's not a guarantee. The staff contact here is a good lawyer, James Trilling in the Bureau of Consumer Protection in DPIP, a good consumer protection lawyer, not an economist, not a person with a competition background. What's his role? What's the chair's role? What's policy's role? I'm not really sure. What are they going to do with economics? I'm not really sure. There's the institutional expertise and there's the individual expertise. Some of the economists who've worked at the FTC who've been most focused on privacy are gone. So there's this guy, James Cooper. Oh, there he is. He was a deputy director of the Bureau of Consumer Protection. He's written widely on privacy, not at the FTC anymore. There was another deputy director of the Bureau of Economics named Andrew Stiver, who's done extensive work on privacy. He's not there anymore. Consumer protection economist Jan Papayardo, she's gone. They have very, very smart people. If the commission wanted to use them, they could. But there's a question, who's doing what and how they're going to use it. And I really see an absence of detail in the ANPR on this. And there's an issue of rigor. How careful are you in doing the requisite analysis of costs and benefits, even identifying costs and benefits, assessing them? What can we measure? What can we estimate? How do we tally it up? How do we approach it? It's all left very vague.
James, I'll turn to you next.
Okay. Oh, do you have a question or
continuing along there?
So, I could go. I'm a BE, Bureau of Economics cheerleader, and so I could go on for forever on this. If the question is if kind of the bigger question that you had originally asked was, what to expect from the comments. I would agree. I think that there'll be a lot. My program, PEP, you guys can see it here. we'll be submitting comments as well, and as you might expect, it will certainly highlight a lot of the economic literature that's out there, and all of it. I mean, it's not, this isn't to be, not all of the work says, that privacy's that not all of the work necessarily cuts against any proposal it's just that economic analysis is something that I think is key. But one thing that I would like to highlight, maybe it switches gears a little bit, is to talk just briefly about the process here. And I feel odd because, gosh, you're the admin law guy on the panel, and I want to talk about a process. But it at the time it happened, I think only FTC real people in the weeds, FTC nerds were paying attention. In the summer of 2021, when there are a few changes made to the FTC's rules of procedure for these Magnuson-Moss rulemaking. Among them were, so when this Magnuson-Moss rulemaking, which Dan alluded to, is very complex, but more so than your plain, your normal APA notice and comment rulemaking. One, if there's got to be a presiding officer, and the presiding officer used to be the ALJ or the chief ALJ. But one of the things that was changed was that the presiding officer now is either the chair or a designee of the chair. Okay. There used to be a staff report, and rules of procedure got rid of the staff report. The other thing has to do, again, this is very esoteric, but it seems to maybe play a role here in the ultimate consideration of the comments, and what the output is that, after they have the ANPRM, which is what we're doing now, if there is an actual notice of a proposed rule that comes out of this, that in that notice, there will be designated disputed issues. Well, it used to be that the presiding officer took public hearings, and the public had a lot of input into what the disputed issues are, and what the disputed issues are could be potentially subject to cross-examination and a lot of interrogation. But now the commission will decide what the disputed issues are in the NPRM. And then finally, the NPRM and the ANPRM, all this jargon, according to the statute and then codified in the rules, had to say with particularity the reason for this, why is a rule needed, but they just deleted the word particularity from it as well, which leads me, kind of, going back to what we talked about. So all of those rule procedure, all of those changes, again, seemingly esoteric and only important to FTC nerds a year and a half ago, may play a crucial role coming up as this is considered, because a lot of the power now is going to be consolidated in the chair's office in order to kind of map out what are the issues that we're going to debate, the factual issues going forward, and then who's going to be actually making some of the crucial procedural decisions going down, and that sort of maps into the rule itself. It has to, the Magnuson-Moss rule has to state with particularity what the problem is. That means that in theory that it's got to be very limited. And so we have this huge broad scope, what is going to pass muster. There's some case law on that, but not a lot, enough. I'll leave it there. But again, some of these procedural changes may limit the scope that some of the comments will be able to have to be able to impact the final rule.
Yeah, and I'll briefly note, it's a curious move for the commission to be getting rid of all of these procedural elements and safeguards. They're there for a reason. They're there to convince reviewing courts that the commission has done its due diligence and is exercising its a statutory authority with care. And where in a era of substantial judicial scrutiny and concern about expansive administrative authority, some of those changes were made prior to West Virginia v. EPA and the major questions doctrine, but that wasn't a surprise. CLE law, questions about abuses of discretion, a scope of executive control. These are all procedures that are going to make it easier for the courts to have a lot of concern about what the commission is doing. I want to turn, Jane, to you next, but I'm going to pivot the discussion a little bit. We have 3 questions that are all somewhat similar, and I'm going to ask all of them. And
wait, can I first comment on the last couple things before we get to questions? Is that okay? I'll be quick, but I think, you know, James and Dan have a very good sense of what's going on kind of internally and at a kind of micro level. I'm on the outside, and yet maybe there's some, you know, what I see, what I sense is that the FTC and both, you know, the policy role of the FTC has turned into something that looks much more political. I don't mean Democratic or Republican, because actually this is, you know, this is one area where there's a lot of you know, crosswinds and agreement. But what I mean is that the theory of what it looks like the FTC wants to do, sort of simultaneously suppressing data collection and data use, while also expecting competition, you know, to flourish, and also expecting services to continue to get better and stay cheap. It just makes no sense. There is no internal logic to it. And so it reminds me, I compare it to politics because it's like the mindset of both wanting low taxes and high spending. There's, you know, I expected agencies, expert agencies, to cut through that, to not be pushed around by sort of impossible expectations of whether it's consumers or politicians, and to actually come to a rule that makes sense. And I have no faith that that's going to happen based on this ANPR. Lena Khan, to me, I do think this is consistent with Lena Khan's kind of vision, but she's, in my opinion, sort of mirror image of Trumpism. It's like a sort of burn it all down, imperial mindset, imperial as in sort of emperor mindset. And so, you know, I know I'm sounding a bit dramatic here, but it's hard to produce comments. By the way, I highly encourage all attendees to please, you know, you have a lot of knowledge. Please submit comments, because I think it is important to have a good record, if for no other reason, just so that in general we can share ideas. That's one thing, good thing coming out of the NPR. But I don't have a lot of faith that there's going to be an effort to really do an analytical, you know, an analytical assessment here.
We have a few questions, and I'm going to probably for our final bit of discussion, ask you all effectively to do the work that the FTC should have done in the first place. So a couple of questions that I think all go to a similar sort of theme. What is the role of safeguards such as de-identification? Should there be a safe harbor for innocuous data use, everyday advertising? Is there scope to apply a reasonable risk-based approach to defining PII to restrict regulation to truly risky cases? Innocuous use would fall outside the scope. And accepting that there are substantial consumer benefits from sharing data with online platforms, do you think there's room for a framework that clarifies data collection practices for consumers that would not be overly burdensome to online activity? If so, what do you think that framework might look like? So I think all of these questions are going to, there are costs and benefits. What would a framework look like, or is there a framework possible that preserves the benefits while helping to avoid the costs? And I will, Dan, you still have your hand up, so I'm just going to jump to you to start with that. We'll go through each of you, and probably we will then need to start wrapping up our discussion. So I would ask each of you to do the FTC's homework for it in a pithy way.
So pithy. Number one, because they're sponsoring this panel discussion and because they pay me, I do want to mention that ICLE is filing comments, extensive comments that I hope will do some of this work, and is posting an executive summary online, I believe today. Is there a framework for considering these things? I don't know. There's room. There are questions about lots of these things. So they don't say what information they're interested in, but they do ask about scope. And so people can comment on that. People can comment on safe harbors, anything they like. It's just one hopes there will be good comments on this. I might also worry that they haven't set forth a clear, focused framework and things could be all over the map.
James.
Oh yeah, sorry. You know, I think they're putting this, you know, to kind of try to answer the question is, you know, what would a reasonable rule look like, which actually kind of sounds like maybe what some of these questions would look like. First, I will just say, I think the FTC's current case-by-case approach is the way to go, not a rule, because look, when people lie about what they're doing with data, I think there should be consequences. I completely agree with that. But I think because of all the heterogeneity out there as far as consumer values, as far as costs and benefits, that the case-by-case approach is a lot more rational than kind of a one-size-fits-all rulemaking. And yeah, you can make a rulemaking that has a bunch of reasonableness qualifications in there, but then what's the benefit of a rule then at that point? If you turn the rule into just a reasonableness determination for every time you use the rule, then you're not really getting the benefit. So I think, that is my overarching views. I don't think we need a rule, not because I don't think that there are not bad practices out there that need to be addressed. I just think that the FTC's current authority has shown that it's really been up to the job, quite frankly. That said, if there were to be a rule, and I mentioned this, I have a kind of plug for an article that I have in Concurrence's chapter on I actually did it back in earlier this year before this was out, on what a privacy rule might look like. And you could imagine a rule, if you think about the specificity and particularity requirements, something grounded in where the FTC has gone in the past, focusing on the unauthorized, unconsented collection of intimate data in someone's home, because that's where they've used unfairness in the TrendNet case and the designerware case. There are a couple others, but that seems for the most part in the Vizio TV case, which I'm not necessarily a fan of, but that still involved viewing data in the home, aggregating that. But you could imagine that a very narrow rule to say, we'll call that an unfair practice, and that's something that will give you a knowing violation will be $45,000 plus per violation. I mean, because we didn't really talk about that, but that's what's at stake here, right? I mean, if once these are turned into rules, a knowing violation of the rule is a civil penalty up to $45,000 per violation. A non-knowing violation is still subject to damages and monetary remedies. So, that's what's at stake here, and we have to think about over deterrence. So I'll leave it there.
And it's worth also noting, when we're talking about per violation in these settings, what is a violation? Is it, if you've got 100 million users and you collect data on 100 million users, is that one violation or 100 million? Well, that matters a whole lot when you're multiplying 40,000 by 1 or 100 million. Jane.
I was going to say, just quickly, by that measure, Facebook got off really easy, didn't they?
Yes. Jane.
Yeah. I mean, so I agree that the kind of case-by-case method, whether it's the FTC or through tort, is often the right way when we're fumbling our way toward figuring out what the best, what sorts of conduct is helpful versus harmful. That said, if there is to be a rule, I do like the idea of defining some safe harbors, so that way, whatever murkiness there is, whether it's through reasonableness or unfairness or something, there's at least some conduct that everyone knows that they can do. The trouble is, I worked with the Uniform Law Commission on their state level privacy law, which I think is pretty good. I wouldn't say it's perfect, but I think it strikes the right balance. And the commissioners there agreed that behavioral advertising would be just a per se okay data practice. I can't see the FTC, given the way they've written this ANPR, going that same way. So, even if they endorse the idea of safe harbors, they might be very narrow. But I will say, like James said, there may be some narrow rules that should be well-defined informational risks or harms that, even regardless of whether the consumer is consented or not, we just are just too risky and harmful. And if they're narrow, I suspect many of them anyways would pretty much fall along the lines of stuff that's liable through tort law anyways. So again, I'm not sure we're doing a lot if we're talking about narrow rules, but in any case, I would certainly endorse that.
Okay, well, we are just about at our time, and I know everyone is just chomping at the bit to flip over to the FTC open meeting. So we will wrap there. I'll very briefly note one other question we had. I noticed that a few of the commissioners offered a dissenting view. Has that happened before? The answer is yes, dissents are common, though perhaps less so when it comes to issuing notices of proposed rulemaking. It looks bad procedurally to have dissents to just notices of proposed rulemaking, the questions being asked. And you would think that a better approach for a commission that wants to survive judicial review would be to embrace the questions that dissents have and get them incorporated into the notice of proposed rulemaking, or ANPR, in order to avoid the dissent. But we are at our time. Thank you to Jane, to James, and to Dan for joining us. I expect are all working on our iterations of comments, so we're looking forward to getting those out and engaging with the commission and everyone else throughout this process. And thank you, of course, to all of the audience members as well for joining us for our discussion today on commenting on the comments and expert take on the direction of the FTC privacy rulemaking. I have been Gus Hurwitz, your moderator, and this has been brought to you by the International Center for Law and Economics.